and it's not planned, and it would be good to have some idea how you would address those kinds of issues should they arise. Statistics say that about half of people over the age of 65 will need some kind of health assistance, long-term care issues, and about half of those people will need some kind of official care, whether it's a volunteer, a family member, or actually in a facility. So the issue starts oftentimes with a health issue, something sudden, a medical emergency or an accident. It can be a slow progressive issue as well, progressive disease like Parkinson's or maybe dementia issues, the elephant in the room. When the caregiver started helping their loved one, they had no idea that the issues would grow so large. And so oftentimes it's maybe even the caregiver and not the care receiver who ends up needing care because of the stress involved in care. So we'll address all of those different issues today. I'm going to talk really quickly. I'm going to present a lot of different issues. So have a notepad available. If there's something that stands out, you say, oh, I need to follow up on that or get more information on that. You'll have at least the title or the highlight of what it was. And I do encourage you to type out some questions you might have to Mary, and she'll insert those so you can get your specific issues, general issues of the topic answered. And then I'll hang around a little bit at the end as well if you have some specific follow-up questions that you want to ask as well. So it may start out as this health issue, which takes you to a hospital, maybe rehab facility, and then do you get to go home from the rehab facility? Are you progressing well and improving to where you can go home, or do you have to stay in a nursing facility, or do you get to go to assisted living, memory care? What is the housing situation as a result of the medical or issue or the emergency that took place? And then typically, as a result of the housing decision, your finances are very different, because what was your budget prior to the health issue rising up or the emergency happening, your budget is very different now, and you find yourself maybe in a situation you had no idea what it would be like. And oftentimes people need some help. You need help financially, and we'll be talking about some resources that might be available financially, but you also need personal help. You need somebody who can step in and assist you. Maybe make your checks, to hire the contractor to build the ramp so you can get back into your house, or maybe to have your medical records sent somewhere for a second opinion, those kinds of things. And it's really helpful if the person you name in your documents knows who they are. You don't want to surprise them. And with a phone call from the doctor or the bank that says, well, you're the agent for your loved one, and would you step in and take care of this issue? So it's helpful to have those kinds of discussions ahead of time. We'll look at those different issues, how they fit together. All of them are addressed in this book, The Accidental Safari, which I have written. And as Mary said, there's autographed copy that's going to be given away here at the end. So hang in if you can, if you're able to do that. Well, the book is a guide for navigating the issues that come and the challenges that come with aging. And there's a lot more stories in the book that I'm able to tell. A lot more issues are addressed in the book, everything from taking the keys away or having somebody voluntarily relinquish their keys when they shouldn't be driving, to Medicaid issues, Medicare issues, VA issues, and they're addressed there. The book tells my story. I was an only child born and raised in Queens, New York. And when I was 12 years old, my mom had a stroke and came home from the hospital and was paralyzed on one side and was in a wheelchair the rest of her life. And so my dad and we took care of my mom for many years. And so I became acquainted with the issues that come with having to be a caregiver. It really changed and redirected my life. It actually, I think, was a good thing, taught me responsibility and those kinds of things. And then fast forward 40 years, my dad then is himself in a nursing home, going into a nursing home. And I'm an attorney at that point, and I realized I didn't have a clue as to how the system worked. How did people pay for that? So that was about 25 years ago. So I had to figure it out for my dad, and I began to incorporate those kinds of issues in my estate planning for people to help them be aware of what the future might hold and do some pre-planning so they could position themselves for Medicaid eligibility if Medicaid was going to be their safety net for care, and to help people be aware of what the other possibilities were.
Richard, Would it be possible for you to wear your headphones, because there's reverb when you talk, and I am recording this, and the audio is so much better when you wear your headset.
Okay.
Thank you very much. I appreciate it. Testing, 1, 2.
Not there yet.
I'm teasing.
Okay, so how's that? Is that any better?
Thank you so much. I appreciate it.
Okay. Thank you for making it better. So let's look at a good starting place for folks, and that would be the legal solutions. And the legal solutions for when it comes to care or help or assistance you might need or be legally authorized to receive from other persons comes by way of powers of attorney. Powers of attorney are legal documents that authorize someone to assist you either physically, medically, or financially, and they can act on your behalf with you or for you. Powers of attorney are effective only while you're alive, and when you die, they become void. So it's helpful to have powers of attorney in place when you need them. And so it's like people ask me, when do I need to get my will? Well, and my answer is, well, you want to get it before you die. So just tell me when you're going to die, and we can make an appointment to come in before that. So it's just something that should be in place. In our office, we typically do powers of attorney financially separate from powers of attorney medically. You might want to name different persons on those powers of attorney and different family members or people who have expertise in certain areas. And doing them separately allows that to happen. And then with the passage of the HIPAA, Health Privacy Act, in the early 2000s, there's a lot more that needs to go into a medical power of attorney. So I think it's helpful to have them be separate. Many of my clients are seniors, and the older you get, the more likely you are to need some assistance. And so I think it's very helpful if powers of attorney are effective when you sign them. Traditionally, powers of attorney had this effectiveness clause that said my power of attorney is effective upon my incapacity, which is evidenced by a letter from my doctor. And so if you have a power of attorney, pull it out and see when it is effective. And again, in my opinion, if it's effective immediately, it's going to be most easy to use for the persons you have named. And that's the second issue. Who have you named in your power of attorney? Typically, if you're married people name their spouse. And what you forget is that your spouse is aging at about the same rate you are. And so if you're naming your spouse, when you get to the place where you might really need somebody to step up and act on your behalf, maybe your spouse is not the person who should be doing that, or maybe they're thinking the same thing. Boy, I'm sure glad my spouse is going to take care of this today, and they're thinking the same thing for you. So I encourage people to consider naming a co-agent with your spouse. Even if you're single and you're not married, I think that it might be helpful if you, in your powers of attorney, named two people, named co-agents, with a clause there that says co-agents can act separately. So if you have a couple of people who love you and can agree together on what's in your best interest, they're joint and severally liable for what they do. And so they have to communicate, they have to agree, but typically the document says they can act separately. So either one can step in as the need arises. Maybe one person is more of a paperwork type person, managing the bills or doing that kind of thing. The other person is more of a doer, I don't know, cleaning out the gutters or just getting things done. And if they could work together, I think it can really enhance the need you might have for assistance at the time you need that assistance. So consider who that might be. I have to say, though, if you have two children who have pretty much hated each other since birth, naming them as co-agents on your power of attorney is not going to be the healing salve that brings them together. Name two people who you think can work together on your behalf. So who are your agents and when is effective? Those are, I think, essential things with powers of attorney. The other document that's really essential while you're alive is your directive to physicians. In other states, they call it a living will. Now that's different than the PULSE form. I have a PULSE form here, the lime green form, and it stands for Physician's Orders for Life-Sustaining Treatment. Okay, and your doctor may have asked you to fill that out. Under A, cardiopulmonary resuscitation, it says the person has no pulse and is not breathing. And then it says attempt resuscitation or do not attempt resuscitation, allow a natural death. So what do we call someone who has no pulse and is not breathing? Well, we call them dead. So if that happens to you, your heart stops, and it's a lot more common than you might think. And it's not necessarily a heart attack. It could be a cardiac arrest where your heart just, for electronic impulse reasons, stops. And if someone were to apply CPR, they could keep you alive until the EMT showed up, and then they can paddle you and with the paddles and get your heart charged again, get it beating again. And so they're asking you here to make a decision if there is no pulse and no breathing, what should happen. So if that happens, you had the cardiac arrest and someone knew enough to give you CPR and 911 showed up. If you had this form and it said, do not attempt resuscitation, that's what they would not do. They would not attempt resuscitation. However, if you don't have the form, then the EMTs are going to do everything they can to resuscitate you, revive you, stabilize you, and transport you to the hospital. And so I tell my clients that you probably, if you want people when they show up to help you and give you any aid that's possible, whether you're able to communicate or not, you really don't need this form if you want the EMTs to revive you and all. However, if you go to bed and you pray, Lord, oh, my life is in such a bad state, I'm in such agony, or I have this terminal illness, and it would be nice if I woke up in heaven. And if that's your prayer, then you would want a pulse form, and you would want to carry it in your top pocket or have it tattooed to your chest or stapled to your chest. So when they went to give you the paddles, they would see the form that said, do not resuscitate, if that's your goal. Yes, Mary.
Hi. So you'll know I'm going to ask you a question when I take my little post-it note. When you move around, your voice goes in and out. So you need to move your mic closer to your mouth, please.
Oh, thank you. Right.
Yeah, and I've checked, and everybody has they're on mute, so things going in and out.
Okay, I'll try to hold my head a little stiller. Okay, so physician's directive, that's a form that is asserted by the persons you named in your power of attorney for healthcare at the appropriate time. So if death is imminent and you're unable to communicate, then you would need a directive, something that directs the physicians as to what to do at this time. And the person you name in your power of attorney for healthcare is the person who has the authority to say, okay, doc, this is what my loved one said they would want if they were dying and they couldn't communicate. And we all agree that's the situation now. They're knocking on heaven's door and they're unable to communicate. And they said they did or did not want a feeding tube, or they did or did not want to be resuscitated. They did or did not want pain medication. So it's a list of actions that you would want the doctor to take, or to be sure they don't take, if you were dying and you couldn't communicate your wishes at that time. So those are vital documents while you're alive. Financial power of attorney, medical power of attorney, directive. And really everyone should have that. Having those documents in place avoids the necessity of having to have a guardian named for you should you become incapacitated and mentally incompetent. You fall off a ladder and you hit your head, and or God forbid, you could even be a young person, in your 20s, you could be, in college and you have a car wreck and some decisions have to be made about your care. Well, who's legally authorized to make those decisions for you? If you don't have a document like a power of attorney in place, then the court has to decide who can make those decisions for you. And so it's documents that are easily done and can need to be there in case of an emergency, and they could create or eliminate a lot of hassle that, especially when in an emergency time when things need to be done quickly. Okay, the other next document. So those powers, all those documents void when you die, and then the will kicks in. So this is a typical estate plan for a couple. We picked a asset amount of $700,000. There's no magic in that number. Just pick the number, a home value, and other invested or IRA or other kinds of assets. Okay, and this is a typical I love you plan. So the first spouse dies, all the assets go to the surviving spouse, and the whole $700,000 then becomes the property of this, the separate property of the surviving spouse. So this is a typical estate plan. Most people have this, married people have this kind of estate plan where the assets go to the surviving spouse. If that's your plan, it can you can avoid having to do a probate or other documents to transfer assets when the first spouse dies. You don't have to use your will if you have a community property agreement. It's a simple document, a couple pages long, and it just basically says all of our assets are community property, and when one of us dies, it all belongs to the survivor as their separate property, and both spouses sign that, and it's notarized. So that would typically be a document in an estate plan for a couple. Now, down at the bottom, you see that a problem can arise, however, if the surviving spouse is maybe in poor health or failing health, or ultimately is in poor health, because what happens is, in order to qualify for Medicaid or VA benefits for long-term care, especially for Medicaid, the limit is assets, liquid assets available have to be under $2,000 to qualify for Medicaid. We'll talk about Medicaid a little more later on. For VA benefits, it's $125,000. So if all the assets go to the surviving spouse, those assets have to then be spent down. So is there a way around that issue? And there certainly is. So you could do an estate plan that says, when I die, the assets I control, my half of the community property, or for some reason, all of the assets have come to me. And that could happen if, let's say, my spouse needed care. My spouse needs care. You're allowed, the Medicaid rules allow the assets, the joint assets of a couple to be transferred to the well spouse. So the well spouse can control all the assets to make the spouse who needs care eligible for Medicaid to pay for their costs of care sooner. So let's say that happened. If all the assets came to me and I'm the well spouse and my spouse is in the nursing home receiving care, and then I die suddenly before my spouse was in care, if I had the other will, everything would go to my spouse who's in the nursing home, right? However, if I have a will that says at my death, those assets I control, whether it's all the assets or my half of the community property, those assets I can control go into a special needs trust for the benefit of my spouse. So they don't go to my spouse. My spouse cannot be the trustee of the special needs trust. She would be the beneficiary of the trust, but she can't be the trustee. So I would name one or two of my children as co-trustees of this trust for the benefit of their parent, their mom. And so that keeps the special needs trust asset is a safety net for my spouse who might be in the nursing home, and they could qualify for Medicaid to pay their bill for the basic cost of care, but this special needs trust is a safety net to improve her quality of life. If there's some additional things that she might need that would help her in her quality of life, maybe she needs more showers during the week, or she needs additional therapy, or one of the grandkids is getting married, we want to hire a caregiver and transport her to the wedding or the graduation, the special needs trust can provide all of that quality of life, and then at her death, whatever's left in that trust would go to the children or residual beneficiaries, whoever they may be. So that's an option in estate planning to provide that safety net. I see some couples, they come in, I call them the teepee couples, like a teepee, they're leaning on each other, they're pretty frail, they're aging. It's amazing how frail you can get if you go through life with somebody who loves you and is assisting you. And so with a couple like that, it seems obvious to me that this is an essential kind of planning, because if one spouse dies, the other spouse would not be able to live alone. So they need to have a plan that's going to accommodate that. So I did an estate plan like this for a couple some time ago, and then they came in about 6 or 8 months later, and one of them had been diagnosed with a terminal illness. Now, they were not going to aggressively treat that. she was going to go on hospice. And so they asked if there was anything else that they should do. And I said, well, it sounds counterintuitive, but at this point, you should transfer all the assets to the well spouse. There's no penalty under Medicaid for Medicaid eligibility if assets are transferred between spouses. You can't give them away other places to kids or charity. There's a question on the Medicaid application that says, have you made any gifts or transfers in the last 5 years? So you have to keep that in mind, okay? But that doesn't create a penalty transfers between spouses. So I suggested you might want to transfer all the assets to the dying spouse, which they did. No penalty for transfers between spouses. That spouse then died, and her will said, well, when I die, all the assets I control go into this special needs trust for the benefit of my spouse, which they did. And so now there is this special needs trust for the benefit of the surviving husband who could not live alone because their care allowed each of them to live together, but neither one could live alone. So when she died, he went into care and was eligible for Medicaid to pay for care, and their life savings, which was about $500,000, was in this special needs trust as a safety net for the surviving husband. So it's very helpful. It's critical, actually, in situations where there's a possibility of long-term care down the road. And unfortunately, that's with a lot of couples, a lot of situations. But what if you're single? You don't have a spouse. Well, then you don't have a spouse. You don't have someone to push the assets to if you are the one who becomes ill. You know, if you're the one who it looks like I'm going to need long-term care, either because I have this progressive disease coming, or I have this sudden medical emergency, or I have the accident, I'm going to need care. I don't have a spouse. So what are the options? Are there any? Well, one option is you spend it all down for your care, and when your assets are under $2,000, then you can qualify for Medicaid. What about a way around the problem? Is there a different way to address it? There is, but the solution is subject to the 5-year look-back period, okay? So, and most of the folks who come and want to look at this option, they're people who their spouse became ill, was in long-term care, and then died, and they realize that this can hit out of the blue, and it can be very expensive, care can. And so is there a way to try to salvage, still protect myself, but salvage some funds possibly to the kids? And so there is. So the process would be that the parent would make a gift to the children. Maybe they want to gift the house and say $50,000. They'd like to see the kids ultimately end up with that. The parent wants to keep the other liquid assets available for themselves to manage and keep. So they make the gift. The kids then take that gift and put it into an irrevocable trust, special needs trust for the benefit of the parent. This protects the parents because the kids can't take the funds and can't sell the house out from under mom and can't take the funds and go to Las Vegas. And so it protects those funds. The parent is the beneficiary of the trust, and the 5-year clock starts ticking when the gift is made. Okay, if mom is fine and healthy for 5 years or more, at the time she may need Medicaid, remember the application says, have you made any gifts or transfers in the last 5 years? So it's been more than 5 years since mom has made the gift, and so she can honestly check the box, no, I haven't made any gifts in the last 5 years. And so that the special needs trust that was established for mom is not preventing mom to be eligible for Medicaid at that time, because it's been more than 5 years. But so you're asking, well, what happens if mom gets sick in less than 5 years? And so if mom gets sick, let's say in year 4, then the assets in the trust, mom would spend her money for her care. When it's gone, the assets in the trust would then begin to pay for her care to get her past year 5. Okay, once it's past year 5, then she could, again, honestly answer the question, it's been more than 5 years, so I haven't made a gift in the last 5 years, and she would be eligible for Medicaid. But what if she gets sick, let's say in year 1, right after she sets this up, and the kids set it up, then she gets sick, and so the assets, she spends her assets down, and then the trust begins to pay for her care. She's in a facility, the house gets sold, and then those funds get used for her care, and the trust runs out of money in year 4. So it's all been spent down for mom's care. Fortunately, there's a rule that says if you make a gift, that makes you ineligible to receive Medicaid and the gift is returned, then the period of ineligibility goes away. So in this example, mom made a gift and then got sick. And so the gift she made, which was put into this trust, the trust paid for mom's care through those years up to year 4. And then finally the trust was emptied. It was all expended for mom's care. So the gift was returned because all of those funds that mom had gifted were then used for mom's care. So that's another reason why you want to keep it in the trust, because it's accountable in the trust. So the funds in the trust were used for mom's care. The trust ran out of money in year 4. Mom could apply for Medicaid in year 4 and be eligible in year 4. She didn't have to go through for the 5-year look-back period because the gift had been returned. So there is a process for single people to position themselves for Medicaid eligibility as well. Okay, some other issues come up. Oftentimes there's second marriages and the funds that parents thought, well, when I die, most of what I brought into the second marriage is going to go to my children. They never consider that, well, what if I get sick? That I don't just die, what if I get sick and all of the funds I brought in are going to be subject to have to be spent down for my care? What are the options? Well, the option is to transfer the funds to the new spouse. Well, oftentimes the kids are thinking, well, I thought I was going to end up with some funds from dad. And so they need to understand how the system works, you know, so you can buy those kids the book and they can read in the book about how the system works, and then so they won't hold it against the new spouse. Or just connect them to the Zoom seminar, they can get some understanding of how the system works. But oftentimes a family meeting would help explain what the options are and how to follow them. Another issue that comes up oftentimes is estate taxes. So Washington State has an estate tax on issues or assets above $2,193,000. So we'll just say 2.2 million. So assets up to 2.2 million are not subject to Washington State estate tax. Anything above that amount are subject to the Washington State estate tax. Now there's a big gap between Washington State tax and the federal estate tax. The federal estate tax is at $11.6 million. So very few people have that, that issue, but it's not really that difficult these days with housing costs what they are and retirement plans that have been growing over many years to look and see that you might have an estate that exceeds 2.2 million. So the traditional I love you plan, for when the first spouse dies, everything goes to the surviving spouse, could create a estate tax liability. So let's say the estate was $3 million and the first, remember it's community property, so each spouse controls 1.5 million. But if the estate plan says, well, when I die, everything I control goes to my spouse, then the surviving spouse ends up being worth $3 million. So when the surviving spouse dies, there's going to be estate tax on approximately $800,000, which is going to be about $88,000. And so is there a way to avoid that tax, way around that? And there is. So it looks similar to the setup there for the special needs trust. And what we're doing is we're creating a credit trust to preserve the estate tax credit of 2.2 million that each spouse has. So together, a couple would have $4.4 million that they could pass at death without having to pay any estate tax, but only if they preserve the estate tax credit for the first spouse that dies. They don't preserve it, and all the assets go to the surviving spouse. The $2.2 million credit of the first spouse that died goes away. So you have to take some action to preserve that credit. And so this is pictorially, this is what it looks like. The first spouse dies, and our example of $3 million, half of it goes into the credit trust for the benefit of the surviving spouse. Now in this example, the surviving spouse has all the control. The surviving spouse is the trustee of the credit trust and the surviving spouse's trust. The surviving spouse is the beneficiary of those assets, and so she can manage them, or he or she can manage those assets. And so what you end up, you're dividing the assets into two pots, basically for estate tax purposes. Each of the pots in this example has 1.5 million, but they could have, up to 2.2 million in each pot and not be subject to any tax. Actually, at the death of the first spouse, there's no tax regardless of how large the estate is. If it's more than the 4.4 million, you'd end up with 2.2 in the credit trust, and you'd end up with the larger number in the survivor's trust, which would be subject to estate tax when the survivor died, if the survivor's portion was above 2.2 million. Okay, some benefits of doing a trust. It does preserve the exemption of each spouse. It reduces it, or may even eliminate the estate taxes if the overall estate is less than 4.4 million. It eliminates the need for probate in any state, and that's a question I always ask when people say, well, do I need to do a living trust? I ask them, do you own real property and other than Washington? And if you do own property in addition to the state you live in, doing a trust would be a really good idea because it helps avoid probate, not only in the state you live in, but the state where you own the other real properties. You could avoid two probates. Probate in Washington is not very high cost. I'm licensed in Washington and California. Probate in California is an exhausting process, very tedious, very expensive. It's about a tenth of the cost of probate in Washington because the process is much more streamlined. But doing an estate plan as a trust, you eliminate the need for a probate at all. And another issue is the terms of a trust are private. When you are going to probate a will, the will gets filed with the local court, and it's an open document. Anyone can go and look up the will. And so if you have some issues in the family, maybe there's a child who has some addictions or other issues that are causing the distributions to be made very specifically or in under controlled manner, and you don't want that to be a public record. Doing that kind of planning would probably be best in a living trust. So let's look at a comparison here between the special needs trust and the revocable living trust. They look very similar. The special needs trust, however, is created through a probate. The Medicaid rules say that if a special needs trust is going to be created for a spouse, surviving spouse, it needs to be created through a will, and therefore we can't use a revocable living trust to create a special needs trust for a spouse, surviving spouse. So it's going to be created through a probate process. The surviving spouse cannot be the trustee of the trust, and but is the beneficiary, but the trust will not pay for any costs of care that can be covered through any other method. So Medicaid would be a different way to pay for care, and so the special trustees of the special needs trust would not be allowed to spend money on care. But if the trustees decide, well, mom gets better care, or if that facility is closer to us, they don't take Medicaid, but we want mom closer to us, then they could certainly spend the funds in the trust to pay for whatever care they think is best for the beneficiary of the trust. On the revocable living trust side, the surviving spouse is the trustee, has much more control and ability to manage those assets for their own benefit. Okay. So once the legal foundation is in place, if that health issue raises its ugly head, then we have people who are authorized to step in and help, and whether it's a financial issue or a medical issue, and they can aid the person who needs the assistance. So I don't have a silver bullet for the health issue, how to keep you healthy until the end. I had a client tell me, I want to die young at an old age, and don't we all? You want to be healthy and active until we can't be, and then have that be the end of life rather than having a slow slide. But oftentimes we can't control that kind of stuff, even if we eat right and exercise and stimulate our minds and have the right medical team. But life will take its course, right? So I'd like to just talk a little bit about an emergency, the emergency that might start you off on this accidental safari. And it often will take you to the emergency room in a hospital. And I think it's it's vital that you have the person you named in your power of attorney for healthcare be available. Call it your 911 buddy. But again, they need to be authorized to help you. If they're going to show up at the hospital and begin to ask questions on your behalf and want to help manage your care, they need to be legally authorized to do that, and that would be with the power of attorney. So once the power of attorney is in place, you need to be able to identify or help people recognize who that person is. Mary sent out these tip sheets when she sent you the invitation to this seminar, a number of 4 or 5 sheets that you can print out. One of them talks about the healthcare, and I'll show you what that looks like. But as part of that form, at the bottom of that form, there is a cutout of an emergency medical card, and you can print out that form and then cut this out of the bottom of that, and it's fold it in half, and it ends up a 2-sided card, and you can write down the emergency contact person and who would be your 911 buddy, who the person is that you've named in your power of attorney, who you would want to show up at the emergency room if that's where you were unfortunately going to be headed. So if you go to the emergency room and they're going to run some tests to see if they can help you, you're complaining about something or there's some issue, and if there's no problem that they have been able to identify with the test, they will thank you for coming and tell you they can't help you and you're done and ask you to leave. I've had clients tell me that the emergency room even called the cab for them and put them in the cab because they were done. But if you're not, I want to tell you, if your body is telling you, no, there's something that's just not right, I don't feel good about something, then you don't want to go home. You want the cab or the Uber driver or whoever to take you either to another hospital or urgent care, or take you to somebody's home you can trust, who can watch over you for the night so that things don't go sideways and uncontrollably. The other possible result of the test is that they show that there is some significant issue going on which the hospital feels like they can treat, in which case they will admit you as a patient. Unfortunately, there's this big gray area between no discernible problem at all and significant test results. And in that gray area, the hospital doesn't feel free to tell you to leave because the tests have revealed something going on. They would be liable if they just said, there's nothing else we can do, you can leave. So what they do is they offer to keep you there under observation. And they have to give you this in writing to tell you that you're not a patient in the hospital, you're under observation. So what's the difference? Does it make a difference? Well, yeah, it does make a difference, because Medicare isn't, if you're over 65, and Medicare is your primary insurer, health insurer, then Medicare isn't paying yet, because the hospital hasn't been able to check enough boxes on the form to qualify you. If they could, they would admit you as a patient. So they're running more tests, trying to find enough reasons to admit you as a patient. So if you have your 911 buddy there, they can be asking these questions: are they a patient? If not, why not? And remember that he has this old football injury, or you can remind them of certain things that they might be able to check to find enough reasons to admit you into the hospital. And it does make a difference, because if you are a patient in the hospital for 3 days and then you go from the hospital to the rehab facility, Medicare will pay 100% of your first 20 days in the hospital. So if you were a patient in the hospital, Medicare will pay 100% of your first 20 days in the hospital, and thereafter Medicare will pay all but $170 a day of the next 80 days. Most people over 65 have a supplement to their Medicaid care. And if you have a supplemental insurance to your Medicare, most of those supplemental insurances will pay that $170 a day front end if Medicare is paying the back end. So together with Medicare and your supplemental insurance, you're continuing to improve through the rehab. You could get up to 100 days of rehab paid for by Medicare and your supplement. The rehab is expensive. It's typically at a nursing home in our area, which is over $300 a day at a nursing home. And rehab is in addition to that, so it's another $200, $250 a day for rehab. And so you're getting physical therapy and occupational therapy and maybe speech therapy. And that mounts up, over $500 a day with the therapy and the cost of care at the nursing home. 100 days, that's over $50,000 in care. And it all goes back to whether or not you were admitted as a patient in the hospital back when you went into the emergency room, or were you just there under observation? So that's a big deal. You need to know how the system works, and that's how it works. It's explained in more detail in the book. Okay, so now you go to the rehab center. You went from the hospital, they decided you need rehab for whatever the issue was, and you're at the rehab center, hopefully improving. Your 911 buddy's job is not done. So they love you, they're there, they're probably going to be by your side a whole lot more than the rehab. I mean, rehab, even if you're doing all kinds of rehab, you're not going to be doing that more than a couple hours a day, and your loved one is going to be there a lot more than that. And they should be conscientiously documenting your progress. And so they need to create a little notebook and what you're doing and how you're getting better at whatever it is you're getting better at, to document the progress, okay? Because at some point, they're going to, the rehab facility is going to call for a care meeting. And the purpose initially is going to be to outline what your care is. But at some point, the care meeting, the reason for the care meeting is going to be to let you know that your loved one is improved and can go home or has to go home now, their rehab is done, or that they have plateaued and they're no longer improving, and so Medicare is going to end. And so Medicare is going to end on Friday or whatever day. And they give you this written notice that that's the case. On the back of that notice, there's the information on how to appeal their decision. And that's why your 911 buddy, your attorney, in fact, under your medical power of attorney, has been keeping track of any progress they see that you've made, because they're the ones who are going to make the phone call for the appeal. Now, believe it or not, the facility probably wants you to make the phone call to do the appeal, because they're telling you that your loved one has plateaued and Medicare is going to end, because they are no longer able to justify on the records that the rehab is necessary because you're improving. If they can't show that, then Medicare doesn't want to pay anymore. So they don't want to be in a position where if an auditor came in for Medicare, pulled the file, they would say, well, look, you continued to provide rehab to this person who is not qualified to need the rehab. And so you want to make the appeal, make the phone call, and explain to the person why your loved one really is improving, or why they need to be, Medicare needs to be extended. So I had a case where the gentleman went to the hospital and was examined, had a couple of TIAs, mini strokes. There was nothing that they really felt like they could do. They didn't want to send him home. They kept him as under observation. The next morning, they were getting him out of bed to do some more testing when he had a full-blown stroke, and he went down and hit the floor, and he didn't break anything, but now that he was a patient in the hospital, and they began to do what they could do to treat that. He was in the hospital for 5 days as a patient, then went to rehab. Medicare now is paying for the rehab. He was not participating in the rehab hardly at all, and so he was telling his wife he just was too painful. You know, he had these black and blue from where he had fallen down, and he tried to do it. He really felt like he was really working hard. He really wasn't participating. So his wife was informed that rehab was going to end, Medicare was going to end, and so she called to make the appeal and explain that one of the reasons he's not really participating is it's so painful from where he fell. And so they extended Medicare for another 7 days and continued to try to involve him in rehab. But his stroke was so profound he was unable to really participate. So at the next care meeting, 7 days later, they said his rehab's going to end, Medicare is going to end. And she called again for the appeal, and the appeal at that point was denied. But they got 7 extra days for that reason. So that's how the system works. And so if you're monitoring your loved one and writing their progress down, you have a basis to make the appeal, and you don't have to be afraid of doing that. I encourage you to be prepared to do that. Okay, and this is what the printout would look like in what Mary sent you. And if you're a visual learner, you can see it starts with testing in the middle up on top. And then if you're at the hospital and you're being tested, you're either going to be admitted, or you're going to be there under observation, or you're going to be released. And then if you're released, you go home. If you're under observation or admitted, you're going to go from the hospital to the rehab facility either under Medicare or under private pay, and it just walks you through how that all works. Okay. So we have the underlying legal things handled, and the health issue now becomes a housing issue.
Richard, we haven't had any questions yet, so I figured I'd just throw it out there. Does anybody have any questions? I can see you, so you can raise your hand if you've got a visual. Or don't forget, you can chat me your questions. Any of the material we've covered so far, you need some questions too? Okay, keep going.
Okay, I will. So it says, be nice to your kids, they're going to choose your nursing home. That's not the case, okay? It's not. I want you to know that nobody can make you go where you don't want to go. But as you age, sometimes you lose your focus, and so you have to remain steadfast that you really believe it's your best interest not to do that. So you can dig your heels. And I encourage people to visit your local facilities. You have assisted living nearby. They're probably not opened up yet, but when they open up, they're going to want to give you a tour. They spend a lot of money advertising. I think information is power. So if you go see them when they open up, you can get a sense of what it looks like, how things work. And if you go around mealtime, they'll want to feed you so you can get a free meal as well. Okay, so most people, if asked what would be your plan for assistance, they would say, well, I just want to go home. I want to be at home. I'm comfortable at home. It's probably less expensive at home. What's your plan? What do you think? How do you think that would work for you? And if you come to make an appointment to come and see myself or Tony, we're going to walk you through what that might look like or what you think it could best look like. And like I said, a lot of people think that they want to be at home, and one of the reasons is because they think it's less expensive. But let's look, if you get to go home, let's say you get to go home from the rehab facility and you just need a couple of hours of assistance in the morning, maybe to help you get out of bed and shower and dress and take your morning medications and breakfast. And then in the evening, you need a reverse of that, somebody to provide assistance to give you dinner and help you get back into bed in your evening meds. So let's say 4 hours a day. In-home care from a licensed, insured, bonded agency is at least $30 an hour. So just 4 hours a day, you're looking at over $100 a day. And if you have that assistance every day, you're at well over $3,000 a month just for 4 hours a day. What if your level of assistance requires more than just a couple hours in the morning, a couple hours in the evening? What if you need somebody there most of the day? What if you have some dementia issues or wandering issues? You need somebody there all day long, or to somebody who's going to make sure you don't go out in the middle of the night, in your pajamas, and so you need somebody there 24 hours a day. You could be spending many thousands, $15,000, $20,000 a month for in-home care if you needed 24-hour care. So for most people, that's not sustainable. So sustainability is an important part of your plan. And just kind of a quick review of what the options are. We talked about in-home care. Independent living is another, it's kind of the waiting room or the on-ramp to where the other kinds of assistance that you might need. And there's a naturally occurring independent living, which it's called the NORC, a naturally occurring retirement community, where you live in a neighborhood where people have look out after each other. They go to take each other to Costco or to the doctor or pick up things or bring in the trash cans for each other, that kind of thing. And it can be naturally occurring, or it can be more formal. There's some independent living facilities here in Kitsap where you have some events planned and some trips planned, and maybe they can provide a meal a day if you're interested in that. The formal part is about twice as expensive as the independent living in a naturally occurring community might be. Typically, the entry level for some assistance is going to be assisted living or an adult family home, and those costs are about the same. Entry level is probably $4,000, $4,500 a month, and that's basically with minimal assistance. Typically, people will go to a facility like assisted living or adult family home when they need medicine management. They're kind of having difficulty tracking taking the pills out of the little plastic pop-up thing, and somebody loads it for them, and then they come back and check, and some of the pills are gone that aren't supposed to be gone, or maybe they haven't taken the pills at all. And so they get to a place where they need some significant help or assistance in that medicine management. And so assisted living facilities provide that. Most assisted living facilities have a memory care unit either attached to a separate building or an adjacent building or a wing or a floor. And because the licensing is the same from the state, and so they're able to provide those different levels of care. Memory care is going to be about $1,000 more a month. So entry level for memory care is probably about $5,000 a month. If you're in assisted living and you have a partner, so two people together probably be about $1,000 more per month. So probably to enter assisted living as a couple probably be about $5,000 entry level. Adult family home, that's like it says, it's a home that is licensed to have up to 6 residents. And so the ratio of staff to residents is really high because you're going to have at least one staff member on duty all the time. And that's one staff for 6 residents. Typically during the day, there's going to be at least 2. And so you have 2 adults for every 6 residents, whereas in assisted living, you might have, 1 staff for every 8 or 10 people in assisted living. Nursing home care is the highest level of care. And as I said earlier, it's about $300 a day, or about $12,000 a month now in our area for nursing care. And a continuing care community, that's where all of the different levels of care are available on one campus. And you can move, there's usually a fee, entry fee that's paid down. And I've seen the fee as low as $75,000. I've had some clients go to a high-rise continuing care community in Seattle, and the buy-in was over $1 million. So it's all over the board, and then you pay a monthly fee. The nice thing about paying the monthly fee going forward is it's going to be the same amount whether you're in assisted living or you're independent living or you're in nursing care. You're just paying that same amount, and so it's, in a sense, it's almost like you have this insurance. You never kind of have to be paying $12,000, $13,000 a month for nursing care because you paid your buy-in, and now you're paying your $3,500 a month, and you're going to pay that whether it's independent or nursing care. All of these facilities are going to have these forms you sign. There's a form that says, I waive my right to sue the facility in exchange for mandatory arbitration. There should be a heading on that form that says you're not required to sign this form. You never want to give away your right to sue the facility. Should something occur that they're responsible for, you can always bargain that away later if you're going to settle, but you don't want to sign that form, nor do you want to give your agent and your power of attorney the authority to sign that form for you. So typically in the powers of attorney, we have a paragraph that says my agent is not authorized to do that. Okay, still no questions, so I'm going to forge ahead. Okay, so now we have the financial, that went from the housing to the financial issue because your budget has changed because of the physical medical issues that have arisen. So what is your plan? From the financial perspective, is it sustainable? And if it's not, are there any other resources that might be available that you could pull in to help extend the sustainability of your plan? And if not, what is your plan? What's plan B? And is that plan sustainable? I have a whole chapter in the book that talks about sustainability and how to approach that. I'm going to talk briefly about these different resources that can be available to help extend the sustainability of your plan. This is, again, if any of these you think are applicable to you, take note, and we can talk about these later on, or you can do some additional research yourself. So long-term care insurance. The traditional policy was like a car insurance policy where you paid so much every month for the rest of your life. Once you bought into the policy, you would pay monthly payments. And it was not, unfortunately, not uncommon to get a letter that says from the insurance company, we're sorry to inform you that we have to raise your rates. And now years have passed and you're much closer to needing the insurance but the costs are going up. And so I've had some clients who say, well, I stopped paying it. Well, well, you stop paying it right at the point where you're likely to need, more likely to need it. So the insurance company or insurance industry has really changed how that works. And so they have these new kinds of policies that are called hybrid policies. And the hybrid policies have combined life insurance and long-term care insurance. So you're buying the policy up front so you don't make monthly payments. It's paid for. And then if you die never using the insurance, your estate gets back all or almost all of the money you paid to be covered during the rest of your lifetime. If you end up using the pool of insurance that is growing over time, then you don't get the life insurance component, but you got the value for the long-term care insurance. So I'm told that 60 to 65 years old is about when the value begins to peak and it becomes almost cost prohibitive after that. So if you're under that age or about that age, you might want to get a quote or two for different policies that are available and see if it might work for you. Okay, then there's VA benefits. So my partner, Tony Hinson, will be addressing these in detail on his Thursday presentation. I'll talk about a basic pension for VA benefits, dependent indemnity compensation, and service-connected disabilities. The basic pension is available to anyone who's been in the service for at least 90 days of active duty during a period of wartime. Dependent indemnity compensation is for spouses or children or even parents of people who have died while in service or as a consequence of their service. And service-connected disability is disability payments that can go to the service person themselves for different levels of disability they may have received. So tune in to Tony on Thursday to get the details of each of those different programs. Okay, then there's an ABLE account. So what is an ABLE account? It's connected with a 529 educational plan, if you're familiar with that, but it stands for Achieve a Better Life Experience. And this is for folks, and you may have someone in your family who's disabled and qualifies, or you know someone who has someone in their family, maybe they have some addictions or they have these disabilities, and they're receiving supplemental Social Security or Medicaid. These are two programs that are asset dependent. So you cannot have more than $2,000 in assets and qualify, liquid assets, and qualify for SSI or Medicaid. And if you're on those programs and you get an inheritance or you earn some money, it reduces your eligibility to, or eliminates your eligibility to those programs. An ABLE account is a way for people who have a disability that was identified prior to age 26 to be able to build a financial foundation. And it's a life changer for those people. You know, if they're disabled, but maybe they're able to drive a car and they own a car and the car breaks down, they don't have $2,000 in their savings account, right, to address that, because you're not allowed to have more than $2,000. This is a way to have an account that allows them to build up either through gifts or even through earnings themselves of up to $100,000 in an account. So you can Google ABLE account, Washington, get some more information on that, or you can give us a call and talk to us about an ABLE account for someone who may be disabled. Medicaid, another program. The Medicaid, for most people, is going to be the financial safety net for paying for long-term care. So let's take an imaginary couple, John and Mary. John has a stroke, ends up at the nursing home. He's not going to go home. Profound paralysis. He's going to be there. He's a healthy guy. Maybe he's going to be there a long time, or maybe he has dementia issues and he's over there. And again, he could be healthy physically and only has some dementia issues. So again, could be there a long time. So Mary comes to see us and says, well, you know, how do we pay for this? So I explain how Medicaid works. And so Mary's the well spouse, so we can transfer all the assets to Mary, okay, at that time. 5-year rule does not apply to Mary and John because they're spouses. No penalty for transfer between spouses. You can transfer the house into Mary's name, the car, between $55,000 and $125,000. So let's use the smaller number, 55. It depends on when you apply, which one of these numbers you can use. So Mary can have $55,000, prepaid funeral for both burial plots, small life insurance policy, personal property of any value. Mary can have all of that stuff, and John can still be eligible for Medicaid. So if that's the case, Mary gets to keep all the income that comes in her name. All of John's income gets turned over to the facility towards his cost of care. Okay, and if that works, if those are the facts for Mary, John would be eligible for Medicaid. Mary gets to keep the house and the cash and everything else. Okay, what happens if John and Mary have $300,000 instead of $50,000? So Mary would be about $250,000 overfunded, right? If she could only keep 55. So the Medicaid rules allows Mary to shelter that $250,000 in a Medicaid qualified annuity, which is an irrevocable annuity that makes payments back to Mary, and it has to be amortized for at least 5 years. And so Mary would have now a larger income, which she gets to keep all the income, and John would be eligible for Medicaid, and that safety net for Mary would include that $250,000 annuity. Okay, a lot more moving parts there to explain, but if that's applicable to you, make a note of that.
Richard, we've got a few questions now. So I'm going to ask them one at a time if that's okay with you.
Sure.
So if somebody has no relatives or close friends where they live, let's see, I have no relative nor close friends where I live. Closest friend will help as financial fiduciary, so I have notarized POA for that, but she doesn't want to be medical liaison. I will have no 911 buddy. Any suggestions?
Unfortunately, this is not uncommon, and there's a couple of ways to go. We're in Kitsap County, so we don't have any local corporations that do that kind of care. In Seattle, they have a number of different companies, and I'll just name one, Guardianship Services of Seattle. So that's a company that they have social workers on hand and RNs, and you can name them in your power of attorney. Excuse me, I'm going to just clear my throat.
Possibly Kathy Tracy and Elaine Morgan too, of caring.
So there are individuals that do that. Unfortunately, though, naming the person now on your power of attorney, it as I said, we live in a rural area, so it's certainly possible that 10 years from now, when you actually need somebody to step in, these individuals who provide those services might not be in business any longer or whatever. I suggest that you see if you can find someone who would be willing to, under that medical power of attorney, be willing to, under specific authorization in the document, then find someone at that time who would be willing to oversee your care. And so, again, what you want to avoid is a guardianship where the court selects someone for you. But if someone you have some confidence in is authorized to look in, you can contact somebody like Mary or look in Compass and Clock, or you could even look at the court's list for professional guardians at that time, and you could contact the person you authorize. Then would be the person in your power of attorney would be authorized to contact that person and then hire them, and then at that time they would oversee your medical care, and they could make regular visits maybe once a month to see how you're doing, and then if some situation arises, they could contact the person who you have on the actual document, who's the decision maker, and say, oh, they seem to be failing in this area, maybe you need to look at an assisted living facility, or they had to go to the hospital for this emergency thing, but I'll check on them every week now, or whatever. So the actual function of the day-to-day function of the medical power of attorney person, or it could be reversed. Maybe somebody doesn't want to be financially responsible, in which case you could get someone who would be willing to hire an accountant to pay your bills for you, or a CPA company to make sure the bills get paid, and then do a quarterly update and accounting for how the funds are and how they're being handled, so that the people you name are not responsible for the day-to-day minutia of carrying those things out, but they would be kind of like the overseer, to just make sure that things are being done properly. So that's kind of a stopgap. If you
Oh,
have
two more.
somebody who's not working with him.
So what do I do with the financial power of attorney to make sure someone sees it? If the will isn't on file with county probate department, does everything get bogged down in long probate?
So, so if you have done a power of attorney, you have let that person know that I have a power of attorney now, and you likely would give them a copy. So they would be aware that if something happened to you, they can step in and do something. And you would have your emergency, contact person card on you. So if it's something that renders you unconscious or unable to communicate, somebody could still call that person, and they would be ready to step up and do something. And then what was the second part, Mary?
Will it get bogged down in a long probate if it is?
Yeah, so probates in Washington, as I said, they're fairly streamlined. So the way they would work is the person you named in your will would have to see an attorney and fill out the paperwork, which is a petition to the court asking that the person be appointed that's named in the will be appointed as the executor. The judge reviews the will, appoints that person as the executor, and then part of their responsibility is file a notice in the paper, a notice to creditors, and that starts the 4-month creditor's claim period. Once the creditor's claim period is over, and even during that period, if there's a house to sell, the executor could sell the house. You can't distribute any assets to the named beneficiaries until the creditor's claim period is over, because some creditor, the person who died might owe money to somebody. If they show up, in month 3 and you've already given the money away of the estate, you can't pay off the creditor. So you have to wait until the creditor's claim period is over, which would be the end of the 4 months. And then you could make a distribution to the beneficiaries after that time. So unless people are fighting about stuff, in Washington, and the other thing that holds things up sometimes is the actual sale of the real property, preparing the property for sale and selling it. But you can start on that, preparing the property and selling it right away when the person dies. But funds typically can be distributed as soon as 4 months after the probate has been opened. But usually it's most often, I would say, done within the first year without exception, unless people are arguing that there's a house that is in disrepair that needs a lot of repairs or it can't sell for some reason.
The last question, I think it's something that you will actually be addressing right now. It says, can they make me sell my house to pay for long-term care? Anything I do regarding house, if I owe on it for many years still, so I can see the screen, and we're talking about Medicaid right now, and also the local Olympic area on aging agency, the O3A, is a great resource to go to get long-term care help and suggestions. And Richard's talking about Medicaid next, but also if you own the house, I don't know how much equity you have in it. You might also want to learn about reverse mortgages, because doing a reverse mortgage can help you with long-term care costs.
Okay, so I'll go on, proceed with the single applicant. So if you're married, you can push the assets to the spouse so that the spouse who needs care can qualify for Medicaid, and the assets can be preserved for the benefit of the well spouse. But if you're single, you don't have a spouse to push the assets to. And so what you need to do there is you have to spend down your assets until you had under $2,000. So in our example, if John wasn't married, John had the stroke, John's in the nursing home, let's say he was retired, had some income coming in, had a nest egg of $40,000 and a house he lived in, he had the stroke and was in the hospital. With his income, he might be able to pay for his care for 4 or 5 months. But then once all of his assets are gone, he could qualify for Medicaid. But you say, whoa, he still owns a house. Well, you can't pay your monthly payments for care out of your house, right? So So you can qualify for Medicaid owning a house and owning a car. You're allowed to have prepaid funeral, burial plots, small cash value in a life insurance policy, and personal property of any value. You can do all that and still qualify for Medicaid. But when you die, Medicaid is going to put a lien against your assets, the assets that you have left at the time you die, if you're single, for repayment of for the cost of your care. Okay, so you can qualify owning a house. So typically what happens to somebody that, in my example, if John's in the hospital, his kids might show up, if he has kids, and say, well, let's rent Dad's house. But remember, Dad's income goes towards his cost of care every month. His retirement gets deposited, and then he's going to turn that or pay that towards the nursing home, towards his cost of care. So if he rents, the house gets rented, the income just from the rental just increases his income, which gets turned over to the facility towards his cost of care. So he's not really farther ahead. Typically what ends up happening is the house gets sold. And so John's on Medicaid, he's Medicaid's paying for his bill, he has less than $2,000 in the bank, the house gets sold, and so now he's got $300,000 in the bank because his house sold. So he's off Medicaid, and he would start to private pay for his care. He wouldn't have to pay back Medicaid for the care that they have paid for up to the time his house sold, but once he got the money, he would start paying for his care going forward. If he lived long enough to where all that money was gone for his care, he'd go back on Medicaid. If he died with still some money left, then Medicaid would put a lien against that for repayment for the money they paid back before he sold his house. And if there's any money left over after Medicaid gets paid back, then that would go to his beneficiaries. Okay. So there are some reasons for not pursuing Medicaid. Medicaid certainly isn't for everyone. Let's say in my example, John and Mary, the $300,000 that they had in the account, it was in John's IRA. So remember, we're pushing the assets to the well spouse. If Mary's the well spouse, Mary has to cash out John's IRA to get that $300,000 over into her name so that she can shelter it. Cashing out a $300,000 IRA all at once going to create a huge income tax bill, probably over $120,000 in income tax. So Mary's in a situation where she has to decide, well, gee, is John even going to be alive in a year? If I'm paying $10,000 or $12,000 a month in care, and I have to pay $120,000 in income tax just to get John eligible for Medicaid, is John's illness going to take his life soon? And so who knows, right? You don't know the answer to those kinds of questions. So it's a very tough spot to be in. So that might be a reason where Mary says, well, I'm just going to withdraw the money monthly from the IRA, combine it with his income, and then pay for his cost of care on an ongoing basis. So they may not want to pursue Medicaid. What about if they had long-term care insurance? They don't need to pursue Medicaid because John's income plus the long-term care insurance could pay for all of the cost of care. Maybe there's a large income. Medicaid rules say if your income exceeds your cost of care, you're not eligible for Medicaid. So that might be a reason that you wouldn't qualify. And some people just choose to self-insure. You know, if they have, my experience tells me that if a client more than $600,000 or $700,000 in investments, their house is paid for, and they have a fairly good retirement account, pension, Social Security, whatever. If they don't want to move the assets around in a way that you're legally allowed to do, just to get qualified for Medicaid. Certainly people over $800 or $1 million in invested assets, they want to control those assets and they want to control the cost of paying for that care themselves. And so they might just have enough funds, they're not interested in qualifying for Medicaid. Okay, so hopefully I've laid out a lot of the issues here and help you to realize that you can address these issues out of a crisis. You don't have to wait for the crisis to happen. You have a whole lot more options. It's kind of like planning a safari versus having an accidental safari. If you plan ahead, you can get some, some good travel arrangements and whatever. And so if you carefully discuss what options might be best for you and you position yourself to be able to take advantage of the things that might serve you best, it makes for a great estate plan that's going to give you some confidence and some peace of mind. What would it cost to come see an attorney, come and see Tony or myself in coming up with a life care plan. And it's different for everybody. You know, it depends on the issues and the assets you have and your health and all those kinds of things. We take that all into consideration. We would go over all of the different issues we discussed. And as part of the seminar, and we're offering a 2-hour consultation either in the office. Most of them are back in the office these days, but you can still do Zoom seminars if you prefer to do it on Zoom, or even a phone consultation. I say seminars, a Zoom consultation. For $100, 2-hour flat fee, $100 for the 2-hour consultation. It takes about an hour and a half to 2 hours to go through all of these issues we talked about. And if you wanted to implement the things we talked about as it relates to a trust, whether it's a living trust or a special needs trust, and incorporate that into your estate plan, the cost is going to be about $2,500 to $3,000 or so. However, you know, if we're talking just the basic will package for a couple or a single person, there's the average cost there. My experience is that about half of the people that come to the consultation, they have done an estate plan fairly recently, and so they just want us to review the plan, look at their estate plan as it relates to the different issues we discussed. And for the most part, those people are just fine. They hear me say that, oh, this is good. Or maybe there's just a little tweaking that needs to be done. Maybe the power of attorney is only effective upon incapacity, or it just names one person and they think, well, gee, co-agents might be a good idea. And so we're just going to make an amendment on that or fix that. And you know, the cost is going to be commensurate with the work. About half of the other half of the people that come, you know, they have never done an estate plan, or their estate plan was done when their children were real little, and now their children have children, and so it's been many, many years. And so they definitely need an estate plan. And so we're going to go over what works for them and what maybe makes sense. And it might be the living trust because the estate is large enough where they need to do some tax planning, or it may be just that their will package needs to include the special needs trust because maybe there's some health issues on the horizon. Certainly, if you're married and one spouse has some diagnosis or is beginning, you know, if you had to look at each other across the breakfast table, you know, you say, well, gee, you know, I have to be honest. I think I'm failing, or I think, you know, this is an issue we have to address. And I realize it's, you know, an elephant in the room, and we help you discuss those things that sometimes are not easy to discuss, but they need to be talked about so that you can maintain as much control as possible. Because once once the circumstances kick in, then you're subject to the circumstances. If you can make as many decisions, you know, I often say I have a lot of respect for the people who recognize, well, gee, I'm at a part of my life where I'm transitioning now into the next phase of my life. And if you can embrace that, you can take advantage of the pleasantries of the next part of your life. Maybe it's moving closer to where your support might be, or moving closer to where medical services might be. You know, you had the gentleman farm and the blackberries are starting to take over. You realize, gee, this is more than I should be handling, or I'm ready to give up the lawnmower, whatever it is. You know, if you're ready to embrace that, it takes a lot of courage to do that. And I respect people who say, well, what steps are the next steps in moving forward here? What makes a lot of sense to do that? So what can you do? Well, you can make an appointment if you feel like the things I have talked about today are things you would like to have addressed and resolved. And Mary can help you do that. I'm glad you tuned in. I hope I gave you some great